This is Scott Drake. Thanks for watching the Legal Broadcast Network. Cleveland Browns wide receiver Donte Stallworth was driving drunk this past weekend when he struck and killed a pedestrian with his Bentley in Miami Beach. Apparently, he blew a .14, which is way over the limit. Again, the pedestrian was killed. No charges have been filed yet. We've brought in Mike Kraut from the Kraut Law Group in Los Angeles for some perspective. Mike, again, worked for over 14 years as a deputy district attorney and a prosecutor as well in Los Angeles. Michael, thanks for talking to us today.
Thank you very much.
No charges have been filed against Stallworth. He's 28 years old. He's cooperating, and he's issued a statement, apologizing, and seems to have deep remorse and regret here. But what kinds of charges is he likely to face?
Well, under Florida law, he's going to face a DUI manslaughter. And a simple DUI in Florida is a mandatory revocation of the license or suspension from anywhere from 180 days to 1 year. But if an individual dies while an individual is driving drunk or under the influence of alcohol, then it's a mandatory 3.5 years of state prison, maximum 15 years state prison.
So this is mandatory.
Under federal sentence, let me start that one again. Under Florida sentencing guidelines, the discretion has been taken away from the judges in Florida. They cannot give him less than 3.5 years or more than 15 years. It is a mandatory prison sentence.
Does the level of intoxication also affect the sentence in this case?
It could only have an effect of the judge giving more than the mandatory minimum. There could be an enhancement for the amount of alcohol. He had virtually well over 1.5 times, almost 2 times the legal limit. You indicated that he blew a .14. In Florida, when there's a manslaughter associated with a DUI, the police and law enforcement are obligated and have the right, against the permission of the suspect, to actually take a blood sample. That was done in this case, and he now faces a significant amount of time in custody. On a professional note, the Cleveland Browns will be able to terminate his contract, which was $35 million for a 7-year contract, because there's a morals clause in virtually every one of the professional sport franchises' contracts.
Talking about the charges themselves here, apparently the victim was just walking home from work after the late shift and I'm not sure, it looks like he might have been on a crosswalk. Would mitigating circumstances, if the pedestrian was at fault in any way in the wrong place at the wrong time, does that have any effect on the charges?
The mitigation really would deal with a civil lawsuit that could follow, but as far as the criminal lawsuit, a pedestrian is deemed to have the right of way no matter what. The only difference would be if, as the gentleman was coming down in his Bentley, if the victim darted out purposely or jumped in front of the car, then of course you don't have the same crime occurring.
And likely there will be, regardless of the outcome of a trial, if there is one, he would be subject to a civil lawsuit here.
Most definitely.
Okay. Once again, my guest is Mike Kraut. He's principal at the Kraut Law Group in Los Angeles. He was a deputy district attorney in L.A. for 14 years and a prosecutor. Mike, once again, thanks for your time.
Thank you very much.
This is Scott Drake. You're watching the Legal Broadcast Network. This is Scott Drake, and we know that as an attorney, you're very busy. That's why we have more content just like this at your fingertips, conveniently located at LegalBroadcastNetwork.com. Thanks for watching.